Okay, I was accused of being a little too monotonous on these and not having a cool introduction, so that song will actually make sense in a little bit for this one. So here we go. So this is Federalism in the Courts, all right? This is the 2013 version of Mr. Kuhn. Okay, so the way the court cases have kind of gone is we've kind of gone through different cycles throughout our history, okay, kind of following the dual um, and cooperative federalisms that we've talked about. Okay, so first, we kind of have a nation-centered courts, meaning that they are generally going to side with the federal government, expanding their powers and letting the Constitution kind of give the government more powers over the states. All right, and that's pretty much from our country's inception until 1835. That date's not magical for any particular reason. It's just when Roger Taney becomes the Chief Justice, taking over for John Marshall. All right, Marshall as Chief Justice was very much about making the central government have more powers. All right, then we go through a state-centered period for nearly 100 years. All right, and the 10th Amendment is usually being used to give powers back to the states. A few minor exceptions around Reconstruction, but for the most part, states start to have more and more powers, and federal government becomes limited. The first constitutional revolution occurs in 1937 with the New Deal. All right, there's actually a case that kind of turns that around. All right, giving a lot more power to the federal government, and that ends with the case you read for homework tonight, which is U.S. versus Lopez. All right, where power starts being given back to the states again from the federal government. And recent cases have, for the most part, been state-oriented, with a few federal exceptions, Gonzalez versus Raich being one, and the Affordable Health Care Act case. I'm not even sure what the technical name was of that one. But more and more cases have been giving powers back to the states since the Lopez decision. All right, so we got a little timeline here to take us through. I'll try and go as quick as I can here. All right, so obviously our first court case, you read about this in your text already. You should remember it from U.S. history as Mcculloch versus Maryland. We know this involves the national bank. All right, you learned this last year. It's one of the things Gorski taught really well. He taught everything well, but most kids come in remembering in the bank and Mcculloch. And in this case, what it's really about is whether or not the federal government has the authority to create a bank. And Congress does create that bank, and then it gets rechartered, as you know, in 1816. But the bigger issue is Maryland tries to tax the bank. And the federal government, or the Supreme Court, says that that is unconstitutional because the Supremacy Clause states that Congress has its power over the states, and the states cannot limit the powers of the national government or tax them. Marshall even writes that the power to tax is the power to destroy. The other thing that came out of Mcculloch, Maryland, is implied powers. And that's the idea that in the Elastic Clause, all right, there are implied powers that are not specifically spelled out, but they are implied, allowing Congress to do other things to carry out its enumerated powers. And that implied power was the ability to create a bank. And since Congress could create the bank, the states could not tax it. That would be unconstitutional. So Supremacy Clause, Elastic Clause are the biggies to know regarding Mcculloch versus Maryland. Sorry about that. All right. Next up, okay, is the Steamboat case, as you might have remembered. Okay. And that is Gibbons versus Ogden. All right. And here we go. All right, Gibbons versus Ogden. All right, this is where the steamboat crossed between the Hudson River from New York into New Jersey and back, and the Supreme Court basically said that Congress has the power to regulate interstate commerce. Congress is the only one that could regulate that trade between the states, not New York or New Jersey, who had given a monopoly for somebody to operate the steamboat. Okay, so the Gibbons-Ogden case is the Commerce Clause. Okay, and Congress has the right to regulate interstate commerce. It already says that in the Constitution, but it's loosely worded. The Supreme Court kind of narrowly defined that to say it's Congress's power. They have the right to do so. Moving along. 1873 are the Slaughterhouse Cases. You might remember this from Reconstruction. And in the Slaughterhouse Cases, we're starting to return some power back to the states, and this clarifies the 14th Amendment a little bit. All right, it's very confusing. It's actually a series of cases. Basically what happens is somebody sues Louisiana for shutting down their slaughterhouse because it basically was gross. They were cutting up the limbs and heads and things and throwing them into the Mississippi River and polluting the drinking water. So when the slaughterhouse was shut down, the owner of the house or slaughterhouse argued that it was unconstitutional because his property was taken away without due process of law. And the Supreme Court basically said that the 14th Amendment purpose is to protect people from racial discrimination and protect people from the state. It doesn't apply in all areas. Okay, so it kind of returned a little bit of powers back to the state, limited the 14th Amendment. All right, not a big one to know. But then we get into 1937 when FDR tries to pack the court. All right, now you probably learned this in U.S. history as a failure for FDR. All right, we're going to teach you here that it's actually a victory for FDR in the sense that he starts getting rulings that he wants to. All right, what's happening is in the 30s, as he's passing this New Deal legislation, a series of court cases are being ruled against him. He's losing 7-2, all right, in almost all instances of his court cases. Basically, the Supreme Court saying you don't have the authority to do the WPA, for example, okay, and some of the other agencies, the AAA, Agricultural Adjustment Act, those are all being deemed unconstitutional because it's not interstate commerce. Therefore, Congress can't regulate it. So FDR basically takes a big gamble. All right, he wins a big election in 1936, huge landslide, and says, I got the people behind me. I'm going to take a chance that the people like what I'm trying to do. They don't like what you're trying to do, Supreme Court. So he proposes adding 6 new justices. All right, 6 new justices. Now, who's going to appoint those 6 new justices? FDR will. Okay. Well, these 7-2 decisions that he's losing, all right, are now going to become 8-7 in favor of FDR and his programs. Okay. Ultimately, in the end, Congress does not go for it. They say that you don't have the authority to do that. Only Congress can add to the Supreme Court. Okay? But FDR has basically fired a shot against the Supreme Court saying, start approving my policies or I'm going to turn public opinion against you. And if the public doesn't support the Supreme Court, they really have no legitimacy. All right? We all know from the Civil War that they lost their legitimacy in the Dred Scott decision, and how'd that work out? Okay? So by packing the court, FDR has basically shifted public opinion against the court and in his favor, and he's expecting them to start ruling in his favor in future cases. We're going to stop it here and pick up in a little bit.